Playing from Galaxy Note 9. Now disconnected from Galaxy Note 9. Welcome back, folks. Welcome back. I'm back. I finished watching my sister. She was on live, and I took some time to chit chat with Miss Dallas. And so now I am back. I'm back. Hey, guys. Hey, Tori. Hey, Shannon. Hey, T Sizzle. T Sizzle, where have you been, sir? Hey, Jana. Black Beauty's in the house. Lovable Leo. Miss Brown. Hey, guys. Good morning. It's still morning. Yes, it is still morning. So this morning, as I was saying earlier, hey Sharon, like this morning, I was saying that I said my prayers this morning, and I spending a wonderful Sunday. Today's my off day, since folks don't think I work. Today's my off day. So I'm on here live this morning because I wanted to share some stuff with you. I'm drinking my water. If I love what is her name? Love me. I'm drinking my water. I forgot your I forgot your Facebook name. I mean your YouTube name. I'm just so messed up with these names. I suck. Hey, Miss Leo. How are you? All right, guys. Last night I kind of got somebody really mad. I got somebody really irritated. I got some folks coming in here saying this is not about Rob. Why don't I stick to my topic of Rob? Oh, I want to show y'all something. Hold on. I got to put my camera on for a minute. They also talk about my camera and I've been doing YouTube for a year and I still haven't upgraded my system. I'm not going to upgrade my system because I'm not a blogger, but I'm just a supporter of R. Kelly. But here it is. Hold on. Let me show y'all something. What is this, y'all? This is what I'm here for. For who? The injustice of Robert Sylvester Kelly. All right. All right, I'm gonna go back off because my camera sucks and they want to talk about me. But here we go. I'm gonna take it off. All right, so that's what I'm here for. That is what I'm here for. I'm not here to upgrade my YouTube channel. I'm not here to be a big blogging superstar. I'm a regular Sally. That's all I am, regular Sally. Standing in support of what I believe, and I fight hard for it. And I go inside the paint. All those who knows basketball terminology, I go inside the paint. Hey, forensic tech guy, thank you. I'm glad you're here because you're my tech guy. All right, guys. I have something to talk about this morning. To all those who were saying that what I was talking about was irrelevant, it has nothing to do with Robert's case, I beg to differ. I'm going to show you why I beg to differ. This morning, I'm going to spend the time reading the hearing, and I'm going to take my time, since I don't know how to read, since I'm going to embrace everything they said about me. They said I was James Earl Jones. I love James Earl Jones. But you know what? I'm going to play something from James Earl Jones. I went to see him when I was in college. I was, I'm telling my age, y'all. I was in college and I went to see him in Fences, right? This is before Denzel played in the part Fences. And he played Fences, and I saw him in person with Ruby Dee. She's, God bless her soul. She's gone now. But she played in the play along with some other people. Ozzie Davis played in it, and James Earl Jones was in it too. So I'm gonna play something that it's like a big little spot in that play. But this is the part I'm gonna play, y'all. This is this is the word that I'm gonna tell that person over there. But listen to what he says here. Hold on. This is his son asking him why don't he ever like him? Why he never liked him? But listen to what James Earl Jones tell his son. Hold
on. A memorable scene by James Earl Jones as a stern father who has struggled to build a life and keep control of his family shows him teaching his son a painful lesson about setting his expectations for affection.
Listen to this part.
Can I ask you a question?
What the hell you want to ask me? Mr. Wiki is the one you got the questions for.
How come you ain't never liked me?
Liked you? Who in the hell ever said, I got to like you? What law is there to say, I got to like you? Do you want to stand up in my face and ask me some damn fool-ass question like that? Talk about liking somebody. Come here, boy, when I talk to you. Straighten up, goddammit. Ask your question. What law is there to say, I got to like you?
No, all right then.
You heard that, right? What law that says I got to like you? I love that part. I love that part. I really do. What law says I got to like you? Shout out to James Earl Jones because that's who they say I am. Shout out to the burglar. That's who they said I am. I embrace every single name that they call me. Shout out to being the ugliest person on YouTube. That's who I am. Now let's get to business. All right. I am here to talk about what people came in my chat yesterday and stated that he has nothing to do. Okay. What did they say? They said him being late on his rent has nothing to do with R. Kelly's case. Who talked about him being late on his rent? I ain't say that wasn't what I was talking about. Miss Brown, they did. They said I'm the ugliest person on YouTube. They said I'm the ugliest person on YouTube. I made a daggone good looking baby being so ugly. That's what they said. But I embrace it, Miss Brown. I embrace the ugliness. Yeah. You're probably right. I'm being ugly right now, right? But anyway, I embrace being the ugliest. I embrace being James Earl Jones, because shout out to James Earl Jones. He never played a part of a degrading part. He's always played good position, you know. He always played high position. He's never taken a role of being somebody less than somebody great. He's always been a great position. He's been a president. He's been a sergeant. He's been a dad. Yeah, he's been a lot of different things. But he's never been a crackhead. He's never been a oh wow. But at least that's a compliment, y'all. They call me James Earl Jones. That's a good thing. Burglar? Oh, okay. But anyway, I embrace whatever they call me. But let's get to business now. All right. The question was posed to me on my YouTube in regards to why am I talking about him? He has nothing to do with James Earl Jones. I mean, I was reading something, y'all. Hold on. Hold on, y'all. Hold on. Did he just post something? Somebody just sent me something. Did he just post something about his history of his income? What is this? Liars, you better, liars get better intel. Okay. I don't know what's that all about, but okay. I'm not too sure what he posts is all about, but he posted something in a community, and I just got it. Somebody sent it to me, but okay. I don't know what that's all about, but I don't know. But anyway, let's get back to what I was talking about. In the hearing, they talked about him helping out with different cases. And what I'm going to do, I'm going to bring it up, because last time I didn't bring it up when I did my live the last time. So I'm going to show it, because I didn't want people stealing my stuff, because I paid $300 something for it. But you know what? Let's go do it. Let's go show it. Okay. I'm going to show it. Okay. All right, here we go. We're going to start off reading. Can you guys see this? Is this big enough for you guys to see? I'm going to move myself out the way so you guys can see this. Is this big enough? I'm going to tell you. Hold on a second. Hold on. Can y'all see that? Is this big enough? Let me move myself out the way. All right. Is that big enough for you guys? Is that big enough? Yeah, they might not like me, but they got to respect me. Thank you, Black Beauty. All right. Is that big enough, guys? All right. So I couldn't get a reader today, so I'm going to have to read it myself, me and my illiterate self. And, when I don't know how to say a word, y'all help a sister out in spelling the word the right way, since I'm illiterate and I don't know how to read. So you guys going to help me with my reading today? Could y'all help me with my reading, since I can't read? I can't read, so y'all guys going to help me? Okay, Elizabeth says she'll help me. Shannon says she'll help me. Okay, thank you. Thank you, Shannon. Oh, he will help me. Oh, you guys are going to help a sister out. Okay, all right. Thank you. I don't know how to read, so I embrace whatever they say. Whatever they say about me, I embrace it, okay? But one thing they can't take away those master's degree from me. And I've never cheated, because, when you do papers, they check to see if you plagiarize it and all that kind of stuff. Never cheat. Never cheated. Nope. I got real grades. I went to class. I didn't cheat. I didn't have anything written in my hand. And so everything was writing. When you go to master's programs, everything's in writing. There's no math to cheat on and stuff like that, And every time you do a paper, they check it within the system to make sure there's no plagiarism. If you don't cite where you got the information from, then you're considered a cheater. So I've never gotten that. And I've gotten 3 masters. Yeah. No, I don't think I'm a cheater. All right. So here comes Sylvia and her non-reading burglar, James Earl Jones, ugliest person on YouTube. I'm about to read this for you guys, okay? You sure can't take away education, Jana. Not at all. But here's what education do. It doesn't make you smarter, y'all. It makes you disciplined. That's one thing I learned about when you in the master's program. You become very disciplined. You know how to research and find things out for yourself. That's what education is all about. Discipline. You know, a lot of people don't have discipline. People go into military for discipline. You know, this is my definition of a master's degree. Discipline in certain areas. Discipline, learning how to be disciplined enough to research and find answers and not having to have other people to search it for you, like some people I know. You get what I'm saying? That's what education's all about. That's my definition. But okay, let's continue. I'm basically answering a question to someone, and I know it came from that side because they're trying to justify the stuff that was said yesterday. They're trying to everybody said, "Oh, we already knew that." I don't think they knew the stuff that is being said. I don't think they really know. They just trying to deflect, trying to move the focus away from the individual who played a role in providing false information to the government. Government, if you're in here watching, I'm going to show you guys something. Just for a moment. Obviously, I must have hit a nerve because he went on his live last night and he had a burger up. And you know what? After he had the burger up, I kind of got hungry because I was like telling a friend of mine, hey, I'm going to go and get me a burger. And you know what, guys? I don't even eat red meat. I stopped eating red meat a while ago. But I had a taste for the hamburger because he had it showing up so long. And I'm like, man, I want a burger. The person said, you better not go out there and get no burger. It was 1 o'clock in the morning. I'm thinking about a burger. And I don't even eat burgers. But it's, you know, that's called mind manipulation. You put something up there enough, you start thinking about that thing, then you wanting it. That's what happened to me last night. And that's what they try to do on a YouTube. That's why they try what they do on Surviving R. Kelly. All of it is to mind manipulate you to believe in something, even though it's not true and there's no facts to it, but they'll get you to believe it if you play it enough to get in your head. And that's what he did to me last night. He made me want a burger. Okay, so let's start this reading here. Just and that's part of education too. You know, they teach you about marketing. I took a couple of marketing classes. Yeah, I did. All right, let's go. Let's get this thing rolling. Oh Lord, here we go. Me and my dyslexic butt again. All right, here we go. All right, I'm going to read it. I'm going to try to do different voices, okay? I'm going to be the judge. I'm going to be the courtroom deputy. I'm going to be all of them, okay? I'm going to change my voices. Since I can't get anybody to read with me, everybody's just scared. But anyway, here we go. I'm going to be the court deputy. I'm going to be the judge. Okay, I'm going to go back up for a second. All of this up here has been stricken out because when the court started, when I was on the call, yeah, I was on the call. When I was on that call listening to the hearing, they muted us for about an hour and some change. And this is the stuff that represent the hour and some change right here. All of this blank stuff, it says, whereupon the following is sealed by order of court. So the court sealed all of this conversation up here. You see all of this? All the way up to 34 pages, they sealed it. So, right. So I kind of wiped everything out and I kind of got to this page. 34 is when you start with the court. This is when the stuff that they released to us to be able to hear. And this is where I was hearing. Ooh, this is where I was hearing. Okay. Can you guys see this clearly? Let me know so I can start reading. Can you guys? Sister! Hey, my sister! Hey, Randa, baby. Randa, I don't have y'all reading no more. Y'all just deserted. Everybody deserted me, but that's okay. Love you guys. All right, honey. See you later. Get some work done. Do some studying. All right, here we go. All right. The court. I'm the judge, okay? For those signing on, please mute your microphone. Miss Nova, do you have the capacity to mute anyone who doesn't mute themselves? Yes, Judge. That's what I'm doing once they come in and I see that their audio is connecting. I automatically mute people. All right. Oh, all right. Very good. If you are signing on to these proceedings, kindly mute your microphone, or the host will mute your microphone for you. Well, someone is still signing on, but I think we are ready to proceed. Mr. Tate, can we hear everybody so far? Can you hear everybody so far? The reporter. I can, Judge. Thank you. Court. All right. This is the day set aside for sentencing the United States versus LM. Criminal number 19-699. May I have appearances, please? First, for the United States. Good morning, Your Honor. Kathy Murphy, Assistant United States Attorney on behalf of the government. And for the defendant, good afternoon, Your Honor. Howard Brownstein on behalf of LM, who is presently on the screen. All right, Mr. Brownstein, welcome you as well. Thank you, Mr. Brownstein. In a moment, I'm going to ask your permission to swear your client so I can make inquiry regarding proceedings by video today. Let me note for the record that through the public website for the United States Court of the District of New Jersey, we have received 3 requests to observe this proceeding link where provided. We have a number beyond 3 persons number, presuming because they are sharing of that link. I was one of the 3. I asked permission and they gave me permission, y'all. I was one of the 3. I was legal there, okay? Because I called in and I, requested through the deputy court and they gave me permission. They sent me the link. Okay, that's how I got in there. But I don't know about everybody else, but all right, let me state for the record and to be absolutely clear that if you are observing these proceedings, rather than I'll say that Mr. Tate is official court reporter for these proceedings and is the only person authorized to make any video or audio recording of these proceedings. This is long-standing judicial conference policy, the law of the United States, and the standing order of this court. Any violation of the rule is subject to contempt power of court and including criminal contempt. The next order of inquiry, Mr. Brownstein, may I make inquiry of your client regarding proceeding by video? Yes, Your Honor. All right. Ms. Nova, could we please administer the oath? Mr. McGee, good afternoon. Ms. Nova, will you administer the oath? Good afternoon, Your Honor. Hello, how are you doing? This is the defendant. You know who that is, right? How you doing? Court deputy says, sir, please raise your right hand. Do you solemnly swear to or affirm that all the testimony that you're about to give in the case now before the court will be the truth, the whole truth, and nothing but the truth? So help you God. Yes. Please state your name and spell your last name for the record. All right, guys, you got it. LMMC. We know the spelling. Thank you. Mr. M, could you either turn your mic up a little or may move closer to your computer so we can hear you a little bit better? A little better? A little better? Okay. Yes, sir. All right. Thank you for that. Good afternoon, sir. How are you, sir? All right. You're in a private residence? Yes, sir. All right. And that private residence is yours? Yes, sir. All right. Are you comfortable there? Yes, sir. Anyone else is present in the room? No, sir. All right. Have you had any drugs, medicine, or pills, or anything that affect your ability to make reasonable decision? No, sir. Do you understand that today is the day set aside for your sentencing? Yes, sir. Do you understand that sentencings are normally conducted in the open courthouse in open courtroom? Yes, sir. So, if you want to have if you want to have supporters there or any other interested members of the public might want to attend, they could do so. Do you understand that? Yes, sir. Did you hear me, y'all? I can attend. I was there. It wasn't illegal. All right, let me go back. Okay. Here come the judge saying that if you wanted to consult with your Mr. Brownstein during these proceedings at any time by being next to him in the courtroom, all you would have to do is lean over, whisper to his ear in his ear. I ask for adjournment, correct? Yes, sir. All right. Now, may you know that the courthouse has been closed for quite some time. I can't remember the last time you were here before me, but I assume we proceeded during the pandemic. That would be by my recollection. Oh my eye, y'all. Oh, my recollection. There's a previous order entered. Miss Murphy, do you recall that I made inquiry of you before about proceeding by video? Yes, sir. All right. One of the ways we're trying to replicate in a courtroom proceeding, in addition to providing access to the public, is to provide you the opportunity to speak to Mr. Brownstein privately. If at any time during these proceedings you wish to do so, all you have to do is ask, and we'll put you on a private breakout room for the purpose of consultation with your counsel. Do you understand that? Yes, sir. All right. Mr. Brownstein, know to ask for that as well if he determines that that's appropriate. Now the courtroom is open for criminal proceeding where defendants do not consent to video. In other words, we could hold a sentencing hearing in the open court in light of the recent order entered by the court. If that were your choice, whether proceeding in person or by video is entirely up to you. Do you understand that? Yes, sir. And you've had the opportunity to speak with Mr. Brownstein about that? Yes, sir. And the consent that you previously granted for the purpose of the video continues through this proceeding? Yes, sir. All right, Mr. Brownstein, you discussed the option with him? Yes, Your Honor. And do you believe proceeding by video is his best interest? Is in his best interest? Absolutely, Your Honor. All right. Could I get a brief pro offer of the United States from the United States about why the United States believed the proceeding by video could be appropriate in this case? Ms. Murphy. Certainly, Your Honor. The United States has submitted a proposed COVID-19 order to Your Honor, which set forth that proceedings today by video is in the interest of justice. First, to ensure that the court is not overwhelmed by cases and proceedings at the conclusion of this period of emergency, particularly in this district, given that there are multiple jurisdiction vacancies. Proceedings by video today, it also permits Mr. M to obtain a speedy resolution of his case and to permit the victim of the offense the ability to obtain a speedy determination of guilt responsibility for the harm caused by Mr. M. Proceeding by video today is also in the interest of justice as it permits the government to obtain a resolution given that the government is operating in a strict capacity in light of the pandemic. Finally, the offense charge in this case occurred between 2016 and 2019. And the government understand that Mr. M would like to move forward and resolve this case without undue delay. All right, Mr. Brownstein, do you agree with this proffer's reasons? Yes, Your Honor. All right, Mr. M, do you agree with those reasons? Yes, Your Honor. Yes, Your Honor. Yes, sir. Yes, Your Honor. All right then. I find that the requirements of the CARES Act and the standing order of the court have been satisfied in this matter. That Mr. M understands his option and that he wishes to continue to consent to video proceeding. We do also now. All right. I would like to begin by reviewing the written sentencing material that have been submitted by the court for consideration here at sentencing. I like to begin with Ms. Murphy, as well as confirm receipt of the President's investigation report and identifying contested issues. And I believe that there are two. First, Ms. Murphy, I received a comprehensive sentencing memorandum and addendum from you as well in support of an anticipated departure. Are there any other written sentencing material from the United States? Ms. Murphy, nothing further. All right. I have a final written President's report dated January 13, 2021. Is that the report that you have? That is the report that the government has, Your Honor. All right. Now, there I believe, two issues where probation differ from the parties' plea agreement. And I believe that they found at paragraph 51 and 53 correct. Yes, Your Honor. That's Mr. Brownstein, y'all. Other than those two issues, which we will resolve at step 1, Ms. Murphy, are there any other objection, correction, or addition to the report? The only correction the government would make is with respect to the final sentencing is paragraph 17. The government respectively request that it be changed to reflect that the hold on, y'all listening to this part here, that the investigation eventually revealed that identities approximately 75 individuals were used as part of this scheme and that a majority of these individuals were inmates. The judge? Yes, I remember that from the sentencing of his co-defendants. Sentencing of co-defendants. Thank you for the reminding me that. We'll fix that in the statement of reason rather than reissuing the report. Mr. Brownstein, any objection to the change? No, Your Honor. All right. Thank you, Ms. Murphy. Mr. Brownstein, the same series of questions from you. I have a sentencing memorandum dated April 23rd, 2021, offering reasons of mitigation of sentencing in support of government's anticipated motion and accompanied by several written letters on Mr. McGee on behalf, speaking of his good qualities, both personal and professional, and in his community. I have read those letters and will take them into consideration here today. I would like to know, Mr. Brownstein, are there any additional written material from the defense? No, Your Honor. All right. And have you had an opportunity to review the January 13, 2021 report with your client? Yes, Your Honor. Any correction, addition, or objections other than the ones that will be joined at step 1? No, sir. All right. Let's turn then to step 1 of the sentencing procedure. Here, the court considers the advisory sentencing guideline or calculation and advisory sentencing guidelines. They are indeed advisory. They're one factor among many that the court will consider in determining its overall sentence in step 3. We calculate them because they represent a benchmark or reference point for any departure or variance that the court may grant on application of the parties or may calculate on its own motion. Such departure and variance are best imposed in conjunction with the accurate calculation of the guidelines to ensure uniformity in sentencing and to avoid unwarranted disparity. So, if we turn to page 49 of the report, you will see that the 2018 guideline is used. Probation concludes on a base level of 7. And then, paragraph 51, we encountered the first dispute that the parties appear to have with probation conclusion. Okay. Probation concludes that the amount of loss in this case is more than $1.5 million. Although just barely, but not more than $305 million. More specifically, $1,506,420.76 and added level 16. Adds level 16 level. Oh, I'm sorry. Add 16 levels. The parties have stipulated to a level and increase of 14 levels with a loss of more than $500,000. But less than $1.5 million. All right. I need to drink some water. Hold on, y'all. Y'all enjoying this so far? I need to take a break for a minute, y'all. Hold on. Hey, spitting fire! All right, here we go. I'm going back to reading again. I'm drinking my water. All right, Solo. I'm loving me. I'm drinking my water. Okay. I get thirsty. All right. Let's see. I need to plug this in. Okay. All right. Here we go. I'm going back to reading my stuff. I'm killing you. All right, I'm going back to read. Okay, guys. I had to play all the parts because nobody would read with me. I don't have my readers no more, so I have to do it myself. The non-reading Sylvia can't read. Sylvia is the one reading it. Okay, here we go. All right. Here we go. We're going back. I had to get some water. The primary, although it's sprinkled throughout the pre-sentence report, the primary base for this conclusion is found based on my review in paragraph 26, 27, and 28. And this is based on this as set forth in the report. The probation officer author's review of the underlying information and investigative document prepared by the Federal Bureau of Investigation. This is found in paragraph 14. I know the United States would stand by its stipulation and its plea agreement and will probably not want to further address this issue. Mr. Brownstein, I'll hear you on it, and I know you object to it, and I understand your argument about the relative role of Mr. Arlene and Mr. M. But this seems to be based on a specific finding that the scheme extended from some period of time after Mr. Arlene ceased. Did he cease? Mr. Arlene ceased activity and some additional losses were incurred. And that's why Mr. M is slightly higher. So it's saying after Mr. Arlene stopped the stuff that he was doing, the other one, the Mr. M, continued. Okay, all right, okay. I don't have any reason to question that other than your objection to it. That the recitation that it relies on underlying FBI records would seem to be sufficient indicating of reliability. How can you prove to me that this number is wrong? Hey, Mr. Brownstein. Okay. Well, I'm not exactly sure how the number came. They came about that number. They came about that number? What does that mean? They came about that number. Okay, I don't know. How they came about that number. How they came about that number. Okay. How the number came. Yeah. Okay, I'm reading it. I'm not crazy now. I'm not exactly sure how that number came. They came about that number. All right. I read it right. Secondly, the court did receive a forfeiture order where the amount is $300,000. What Mr. M was involved in this incident, which is even a guideline level enhancement of 12, not 14. So where they came up with this extra couple of dollars and how they got over the 1,500, and I see where I think Mr. Arning was still involved, but is saying that Mr. M referred people, other individual, Mr. Palino, which I think was someone who is also involved with Mr. Arnie or whatever his name, Mr. A. I'm just going to say Mr. M. I figure out these people's names. Mr. A. and went to a jewelry store in New Jersey, which Mr. M did not know, was not involved in, and never been to New Jersey, and never knew the owner of the jewelry store. So now how this is enhanced and where the initial number come from, I can't understand. All I know is that I received what Miss Murphy sent me in the forfeiture. It was $308,000. We're talking about a minor amount of money over the guideline level of $1,500. $150,000. I'll ask the court to concur with the agreement between the government and the defense in the plea agreement. Okay, the judge. Well, again, Miss Murphy, I'll leave it to you whether you want to address any of this or not. My understanding is from the last sentencing of a co-defendant is that the forfeiture numbers are based on gain, but the calculation of loss is based on loss. And that's the difference why there's a difference. In terms of the jewelry store and all of that, I can only rely on what I've read and what probation has told me, which is what Mr. M is responsible for, those additional transactions as they relate to fraudulent identity. Hear that? Fraudulent identity and or credit that Mr. M was involved in. He doesn't have to put the money in his pocket to be responsible for the loss as a matter of loss determination under the guidelines. if you want to adjourn this sentencing and take this up with probation and ask them, do a show me, do a show and tell, that's the way this really should be addressed. I can't rely on the forfeiture's numbers to dispute this. I would have to see a calculation from you that dispute the probation's calculation. Otherwise, I would find by a preponderance of the evidence as set forth in the pre-sentencing investigation report that has not been specifically challenged, only generally challenged, as accurate and complete. I'll leave it to you, Mr. Brownstein. Well, yeah, Judge, as I said, it is a minor difference level between the level 16 and the level 14, which makes a big difference as far as sentencing is concerned. I don't have the document in front of me, nor did I have the documents for me to calculate what the actual loss was. I don't know the accuracy of the FBI information. I can't say. But for such a minor situation, I'm not going to ask for any adjournment to be able to go back and go through that, Judge. I'll just move forward. And if the court feels an increase of 16 level, I think 14, as we agreed upon, Miss Murphy knew what the numbers were when they came to the agreement. I'll ask the court to abide by our agreement. All right. Well, I offer Miss Murphy the opportunity to represent the court. And she sat down with you and the FBI, and the FBI numbers for Mr. M was below 1.5 million. I just don't have any. I have probation's finding, which is based on the assertion by them that they met with the FBI, they reviewed the records, and they calculated this amount. I don't have anything to undermine that. I'm sorry, I don't have anything to undermine that. And either have got to hear it from them, from the government, and I'll hear it from you. And other than that, Judge, we stipulated to a different number, and the forfeiture number is different. I'll provide the opportunity to you. I'll take it. I will take it. If I accept this, I will still take into consideration at the step 3 the argument you have just raised, which is valid. Is that he goes from 14 to 16, and 2 points ain't nothing but $6,000. That just seems a little out of whack, and that can be taken into consideration in the overall sentencing. I think that's fair, but I don't have any reason to doubt the probation calculation unless you have more, I'm going to adopt it. Miss Murphy, do you wish to be heard in this issue? Your Honor, I can just represent that the government stand by the terms in its plea agreement. Mr. M plead guilty before the other defendants. It reflects a loss calculation at the time he entered the plea, and additional information was provided to probation, and that his loss calculation were you see there. I shared the basis for the loss calculation with Mr. Brownstein, but I stand by the terms of the parties' plea agreement, which is the loss amount and up to $1.5 million and an offer level of 14. But you are not prepared to prove that probation is wrong? No, I don't believe the numbers is wrong. All right. I'm going to accept the probation's calculation and the loss amount and compute the specific offense characteristic as of level 16 and turn to the next issue. From there, 2 points added because there was an unauthorized transfer or use of means of identification unlawfully to produce and obtain other means of identification. Then we come to the next issue, that is joint for the calculation of the guideline. That is whether the defendant knew and should have known that the victim of the offense were vulnerable. I previously applied this to the the A sentencing. I can't recall whether I applied it to the M one or not. But as I discussed very briefly in the modification of this pre-sentencing report, Mr. A, through his own device, apparently obtained the information of the incarcerated individual and then, using their identifiers, engaged in certain transaction and credit line modification, adding in false vendors and set forth in order to boost the credit score of those individuals, and then was going to use those line of credit as he did as part of the scheme. And that Mr. M joined the scheme knowing, here it is, knowing of its extent. Remember, he was lying to say he ain't know all this, blah, 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 blah. But they said he was not. He joined the scheme knowing of its extent. Okay. In light of the use of the vulnerable victims, as I have previously found, in order to further this conspiracy, this seems to be an appropriate adjustment. I recognize that it was not contemplated by the plea agreement, but again, in light of the findings of the pre-sentencing report, it appears that it is an appropriate specific offense characteristic at step 1. Mr. Brownstein, is there anything you want to add to the record or argument to me to convince me that the vulnerable victim enhancement should not be applied to Mr. M? Mr. Brownstein. As I said, the vulnerable victim had no damages done to them based on the scheme Mr. A created. The only one that had damage done was the Synchrony Bank. There was no blank blank in the individuals, inmates, whatever name you want to use, were not vulnerable, were not in any way damaged by the scheme to defraud. They do not owe any money. The only one that is owing money is Mr. M, Mr. A to the Synchrony Bank. And that's what the loss is about. So I don't think the victim enhancement should apply. You know what, y'all? Remember what I was reading yesterday, right? I was reading how they used the different people's name on their utility bills. I wonder if one of those people's name is the one that they use. Those utility bills. Because remember, that wasn't part of the court thing. Now, if they use those individuals' name on those utility bill and left those bills without paying them, just put it on the name and also the car note and all that, wouldn't that be something? Just asking. Just asking. All right, hold on. Let me see what y'all guys are saying. It's been fine. The train not seated. Pack. Okay. Gonna be more train. Okay. All right, I'm gonna keep reading. Okay, we got 90 folks up in this chat. All right, let's just keep reading. Okay. All right, we're going to Okay, he said there was no enhancement of his victim. Okay, here come the judge. All right, well then, I'll hear from Miss Murphy if she wants to be heard on this. I'm not sure I'm convinced of that. To just say he's not convinced that these people were not damaged. Essentially, what happened is the identity of these people were stolen in credit line, which were not, that were inflated and not paid, were in full, were obtained. This very likely would have a negative impact on credit rating of the individual whose identities were stolen, even if decision were not pursuant to them for the loss made. I'm not prepared to find that there were no actual loss or victimization of the individual. Those identities were stolen. They may not owe restitution, but they still had their identities stolen and lines of credit taken out in their name without their authorization. In fact, that is the very nature of the scheme here. I understand that the terms of relevant conduct for them to have been victim of either a state or local or state or on federal crime based on the unauthorized use of their identities to obtain credit. Relevant conduct does not have to be charged. It only has to be fairly established that the government only choose to charge Mr. A and Mr. M and Mr. M with fraud, bank fraud. In this case, conspiracy to commit bank fraud, and bank fraud doesn't mean unauthorized access to credit account, or identity theft was not part of the parcel and parcel of the scheme. In fact, it seemed to me to be to be a central part of the scheme. So I would apply this enhancement. Anything else on that, Mr. Brownstein? No, Your Honor. Miss Murphy? Nothing, Your Honor, from the government. All right. I'm going to add the 2 points and determine the adjustment offense level in is level 27. The probation concludes that Mr. M has accepted responsibility and did so in a timely manner. In fact, I am told that he immediately cooperated. Listen, y'all, here we go. He immediately cooperated with the United States in this case, and therefore I calculate the adjustments offense level as 24. Mr. M criminal history is calculated beginning at the paragraph 61. 1 point is assessed. Okay, 1 point is assessed for an 11-year-old or so 10-year and 10-and-a-half-year-old matter in Illinois that the only point calculated. Because he has 1 point criminal history score, he is he's in a criminal history category 1. Those two things taken together, level 27, rather level 24, did I say level 24? And a criminal history category of 1 means an advisory sentencing guideline ranges of 51 months to 63 months. Other than the issue about the amount of loss and vulnerable victim, are there any other reason, any other objection to the report, and may I otherwise adopt it in full, Miss Murphy? No objection from the government. Mr. Brown? Nothing further, Your Honor. All right. The parties' rights with regards to the two calculation that I have determined are preserved. I'll adopt the findings of the pre-sentencing report in support of those two specific offense characteristic. We then turn to step 2 of the sentencing procedure. The court has provided an advance notice to the parties that its intention to depart from its own and therefore will not depart from my own. I understand from the submission made to the court in camera that the United States has a departure motion. For the record, 51K, and the 5K1.K allows the court to consider the support and any support of departure motion under 5K1.1 in camera. I receive a written submission from the United States as part of the sentencing process here with regards to departure motion. I have considered proffer from Mr. M and Mr. Brownstein in order to have a fuller picture of the basis for such departure. I invite Ms. Murphy to make a departure motion now that she wishes to make. Okay, here we go. Your Honor, the government moves for departure basis on 5K1.1 and support of the government reference to its April. The addendum A to its April 29, 2021 sentencing memorandum. All right, Mr. Brownstein, this is a motion. Do you not oppose? Indeed, I take it that you join in. I do. All right. I appreciate both sides providing information that I can fully consider this motion. Under this motion, the court has the authority to depart from the guideline in the court conclusion after reviewing 5 statutory factors that the defendant has provided substantial, listen y'all, listen to this, that the defendant has provided substantial assistance in the investigation or the prosecution of another person who has committed offense. I am told of 3 separate matters that Mr. M has provided assistance. One is the matter pending, and that was pending in this court or is pending in this court. Mr. Arena A and Mr. M both pled guilty and have been sentenced, and that's a partial basis of the departure motion that has been offered before me. In a related case, Mr. McGee provided assistance regarding Mr. A, which he pled guilty in a state matter in State Court of New York. I have received information from the United States concerning a matter in another federal district, having taken into consideration as part of my overall determination of the appropriate departure. Y'all heard that, right? I have received information. Okay, they already talked about the 2 cases that, the case that he's in, right? The case he's in, right, which is this one here. One matter, because remember there's 3 matters, right? Okay, hold on. I am told of 3 separate matters that Mr. M has provided assistance on, right? One is the matter pending that was pending in this court or is pending in this court, which Mr. A and Mr. M have both pled guilty and have been sentenced. That's one matter, right? Then they talk about, in a related case, Mr. M provided assistance regarding Mr. A. So that's the other case, right? That's the case in New York, right? With those, I think it was 14 individuals. And then also, there's another case. I have been also receive information that the United States concerning a matter in another federal district taken into consideration as part of my overall determination in appropriate departure. Y'all heard that? All right. I'm going to pause for a minute. Okay, hold on. I'm going to finish reading this part. My review of the in-camera submission of those three matters demonstrate my satisfaction that in those three matters, Mr. McGee has provided useful, significant information and that the government concurred that evaluation of the assistant rendered indeed in the present matter before me two significant conviction were obtained against the co-conspirators, right? They got two conspirators, okay? Mr. M's explanation of the scheme and the involvement of others were no doubt, in fact, a factor of this guilty plea. He's to be entitled to departure from that alone. Significantly, he assisted another prosecution entity, another sovereign of another matter related to Mr. A and has been related to me. The investigation in that matter were satisfied with the information provided indeed. The other matter, okay, here it is. The other matter has also been a subject of corroboration. I have received information from the government in camera which indicate that this additional cooperation has been considered by the government to be significant and useful. You notice they didn't say what case that was, but they mentioned the other two cases that he gave information for. They're both related to Mr. Arlene, Mr. A. The court determines that on the record before me that the truthfulness, completeness, and the reliability of that information has been unquestioned by the individual who have related the information to me. I have nothing from the government or reliable source indicating that Mr. M has been anything other than reliable, truthful, and complete in his matter of cooperation with the state, federal authorities. The nature and the extent of the assistance appears to be extensive historically in providing background information that this is given the breadth across jurisdiction. The nature of these schemes and the importance of having an individual with insider knowledge. Insider knowledge makes such assistance substantial because that insider status. The fourth factor in whether the defendant suffered or there any danger of risk to the defendant or his family resulting in his assistance. There's always a risk of such risk anytime anyone does cooperate. Overall, my overall assessment of this, based on the camera submission, is that Mr. M suffered higher than ordinary risks of danger. I'm taking that into consideration in determining my overall sentencing. In terms of the timelines of the defendant's assistant, I am told that from the government that Mr. M cooperated in timely fashion in the matter before me, and in the other state's matter and in the other federal's matter has been unwavering in his ability and desire to provide assistance. So I find on the record before me that Mr. McGee is entitled to a substantial departure. He's entitled to a substantial departure from the guideline calculation, which at step 1. I previously calculated at 51 to 63 months. I will vary or depart rather down 7 level of step 2 to 24 to 24 to 30 month in light of cooperation and the government's motion. Let me ask the United States whether they wish to address the motion any further. Ms. Murphy, the United States does not wish to address the motion any further. All right, Mr. Brownstein. No, it's guideline discretionary, and we will move forward from there, Judge. All right. Then we turn to step 3 of sentencing procedure. Here I offer to Mr. Bernstein the opportunity to make arguments in mitigation of sentence, to offer any additional evidence in which the court to consider. Mr. M., I invite you to address the court personally if there is anything you want me to know before I pronounce sentence. Mr. Brownstein may take those up in order if he sees fit. Mr. Brownstein? All right, y'all, you ready to hear the bull? Okay, here we go. Anybody ready to hear the bull? You guys ready to hear the bull? Y'all listening? Oh, it's like a storybook. Okay, here we go. Mr. Brownstein, I think Mr. M would like to address the court. I'd like to have him to address the court first, if the court doesn't mind. All right, very good. Mr. M, good afternoon again, sir. Good afternoon, sir, dear Honor. Judge Noel Hillman, I understand that my action caused us to be here today. Mr. M, can you speak a little more loudly for me? Because I can hear you, but just can barely. Maybe I'll turn my volume up a little. Maybe that's my problem. Maybe I'm part of the problem. Sorry, go ahead. Well, dear Honorable Judge Noel Hillman, I understand that my action have caused us to be here today. I'm very sorry and aware of my efforts in this case. I am guilty. I knew what I was doing. I knew what I was doing was wrong. I placed the burden on my uncaused family. I should have not participated in any of this. The effects of my action has caused uncertainty in my household. I recently, 2-3 years, have moved over here in search of a better education and school and area for my kids. My wife depends on me greatly. All my children are under my roof. Lie number 1. Not all your kids are under your roof. You got one that you did not take care of. Okay, let me go back. Regress, Sylvia. I understand my family and friends. I'm sorry. I'm embarrassed. I embarrassed my family and friend. My 2 eldest daughter recently graduated from college, but she's not. Oh, Jesus. Okay. My 2 eldest daughters recently graduated from college, and here am I, in federal court about to get sentenced. It is unbearable to look at my kid's face regarding this topic, and everyone is still trying to show me sympathy, but it was just stupid. And I know I'm sorry, and I'm just going to, I don't know. I just want to move forward. I have a plan to pay Synchrony their money back. I should have never gotten involved with this. I should have never gotten involved with him. I knew what I was doing. What I was doing was wrong. I can't lie and say certain people in my life told me it was a bad idea. You know, it was a bad idea, but I was trying to put my family ahead. It was so stupid. It was so stupid. I just wish I would have did things different. I get out of this. I'm going to trucking school. I do not want to disappoint my wife, my kids. I won't be back in nobody's court. I'm going to continue to advocate. Okay, y'all, here come the bullshit. I mean, the bull crap. I'm going to advocate for human trafficking. I'm going to keep going with that. Thank you, Your Honor. All right, Mr. McM. Thank you. Mr. Brownstein. Well, I think all has been said, Judge. I don't think Mr. M, as I put it in my sentencing memo, I don't think I need to enhance more of what I said in my sentencing memo. And to me, my credibility is very important before the court. Maybe in my 47 years career of doing this, I've recommended maybe the number of fingers on one hand that someone shouldn't go to jail. As for a non-custodial sentencing, I don't do that lightly. I don't do that because of me. It's very important that I have credibility with this court. This court has known me probably 25 years when he was an assistant attorney. And it's very important to me that what I say is taken as gospel and as true, and that I would not in any way ask for something I don't think is appropriate. I think if the court has departed down to 24 months, it's a discretionary guideline number. I think personally that, and as I said, Mr. M should be a non-custodial sentence. The reason why I have already articulated, he's still doing he's still doing things to help individual in society. His blog still helping young women. He is still helping little girls. Still helping society to prevent the predators and the pedophiles and preying on these young children, vulnerable children. I think now, y'all hear this, right? And then they say that, okay, all right. I think that to stop him and to prevent him from continuing to assisting, you hear this, right? In many different areas, and putting him in custody will not accomplish anything but hurt the good that he's done. Okay. Should I read that again? Okay. Should I read that again, y'all? Should I read that again? Tell me, should I read that part again? They're saying that he has nothing to do with Robert's case. Did they not just say that? Should I read it again to you guys? Should I read? Put a 1 if you want me to read that part again. Put a 1. Put a freaking 1 up there. I want to see the ones. If you want me to read that again. Read it again. Do y'all want me to read it again? And these people keep saying, "Oh, what are you doing? Ain't got nothing to do with Rob. No, I don't know why you keep saying that. Oh, she do this. Your life is supposed to be about Robert. Why are you bothering him? Why he ain't doing nothing to me? Yeah. You know, why you keep talking? Stick to the topic. He don't have nothing to do with Robert. He had nothing to do with it. No, why are you bothering him? He don't have nothing to do with Robert. You need to stick to the topic. He's not bothering you. No, he's not. He's not bothering you. Why you keep bringing him up? Why you keep bringing him? He has nothing to do with Robert. His case ain't got nothing to do with Robert's case. I'm showing you it in the pudding. It's in the pudding. It's in the facts. It's in the writing here, okay? Did y'all hear it? Did y'all hear it? It's in writing, y'all. It's in writing. Okay, hit your head for me. Some of y'all, guys, go knock a hammer in those people's head over there and tell them put some of the brains and logic in their head. Because they keep saying, why are you talking about him? You just as messy as hell. I thought you was a Christian. Or who's doing this? Why you keep bringing him up? He didn't do nothing to you. Why you keep bringing him up then? Why his case ain't got nothing? Oh yeah, he already told us about that. But fools, y'all, listen, Linda, listen. Okay, I'm gonna read it back to y'all. Hold on, I'm going back to read it to y'all. Hold on. Here's what his attorney says in his plea for him not to get sentencing. This is what his attorney said. He wants him to be in non-custodial sentencing. You know what non-custodial sentencing means? It means for him to be not locked up. It's not, he could get the freedom of being outside. Okay. His sentencing should be like him being house arrest. That's what he want him to do. You know, that type of stuff, right? He does not want him to be in custodial setting. Custodial setting is behind bars where they watch you 24 hours, 7 days a week. That is custodial. It's like somebody watching over you. You know, that's what he wants him now. But here's the reasoning why he should not do it. The judge should not give him time. His attorney's pleading that his is like the first, he count the amount of time he has asked the judge to not give anybody any behind bars sentencing is because this guy here, he feels strongly that this guy has been doing so much work. He has helped in cases, and his blogging has been helping little girls, young women. And if you put him behind bars, he's not going to be able to continue the work that he's been doing for these people. The work, meaning the stuff that he has been providing to the government. If the government puts him in jail, how is he going to get the rest of the information he started giving? It's in the pudding. It's proof is in the pudding. And all those freaking supposedly R. Kelly supporters who's been following this dude, y'all part of it. Y'all part of it. I'm telling you. All of y'all, the proof is in the pudding, is in the writing right here. No, but then y'all come up with some excuse like, oh, no, that's not what the government made these stuff up. Then he ain't do that. Nope. My golly gee. And listen to this, y'all. The main supporter of supposedly the Mentee. Mentee been rocking hard with this dude, y'all. Hard. Been rocking so hard with him. But I digress. I won't keep it going. I'm going to finish reading my little thing here. Hold on. I'm going to read it. Mr. McM should be non-custodial sentencing. The reason why I have already articulated that he's still doing things to help individual in society. His blog is still helping young women and helping little girls, still helping society to prevent, look, did y'all see that? Prevent predators and the ugly word and preying on these young children. Vulnerable children. You see how they try to put that up? Okay. I think that, okay, y'all, who has this dude been talking about throughout the whole time he has been on social media? Has he been talking about anybody else other than Mr. Kelly? I'll wait for the answer. Hold on. Let me wait and look at y'all. I'm waiting to see your answers. It's a delay. Sharon said, where are these these girls that helped with the 1.6 million he stole from the 79? LM is a liar and thief and a snitch, and the lawyer is supposed to say. That's what the lawyer is supposed to say. Okay, I was just waiting, Crystal Man. Thank you, Rita, for answering my question. And you see what it says here. I think that to stop him and to prevent him from continuing to assist in his assistance. Who has he been assisting the government? In whose case? Mr. Kelly's case. Cause you remember, I'm gonna play something. He got what? Hold on, we gotta play something. Hold on, y'all. Hold on. Let me go. Hold on. Hold on, y'all. Hold on. Let me tell you. Hold on. We got. I'm gonna play something for y'all. This is what he got people to do. Remember we played this before? Hold on a second. I gotta get it for y'all. I gotta put a reminder in your head of what he did. Hold on. I got mute for a second so I could pull it up and find the right one. Hold on. Okay, yeah, I found something while looking for something. Yeah, I found something. Hold on a second. This is something that I found. Hold on. In my stash of recordings of lives, because all the lives are disappeared now. But listen to this. Listen to this. Listen. This is, I think he was talking about the dad. Hold on.
Ever. Cause the number one reason was this, because I would have never done that. And I asked him not to do it. I said, don't go live. Don't get into something that you wasn't there for this and you wasn't there for that. But it was exposing the women that's supposed to be over here, that's supposed to be messy. Right? Well, let me let y'all know first. I ain't turning my back on no motherfucking body that's over here. So if that makes us not friends, then that's just what it is.
Okay. That was something it's more to it, but I was like, wow, I have this in here too. Y'all, I collected a lot of stuff. I've been like, whoa, busy little beaver. But let me tell y'all, gotta remind y'all that little recording. I keep playing that one, y'all, for you guys to remember what he said. He got people to lie. He got the storage. He got this. He's been an instrument in helping in the case, y'all. He was very instrumental. Very instrumental. He is the one that got all the information on Mr. Oh, y'all, I gotta get off the phone in a minute because I've been trying to do this interview with this lady for the longest, and she just left me a message. You know, I'm gonna hold on. I'm gonna take care. Hold on, let me just do this, and then I gotta get off because I think I'm on work today because I've been trying to get these people to do this interview and have not, and they just called me. It's a good day. It's a good day for work too. Hold on a second. I tell you. A woman's work is never done. A woman's work, a woman's work. Oh, let me stop. I can't sing for the lick of it, okay? But I know how to say that word. Hold on, hold on. Okay, hold on. Here we go. Here we go. All right, here we go. Ready? This is the one I was looking for.
He still ain't on it. In truth, we did our job. We brought the information to the public. Surviving R. Kelly went off. We kept that shit going. We got bus drivers. We got police officers. We got assistants. We got friends. We got people to lie. We got the storage. We got motherfucking video, audio. You have seen Asriel at my house. You have seen parents at my house.
Doesn't that sound like tampering with a witness? He said you have seen blank at the house. You have seen people left the house. You have seen this. I got the storage. Yes, Lori. But guys, I will continue with the rest of the reading later on because I have to go ahead and do this interview because this lady just called me and I've been waiting for her for several weeks. And I need to go ahead and knock this interview out and get these things caught up. But I will continue reading this later on. Y'all remind me where I left off because since they claim I don't know how to read. So I'm learning how to read with you guys, okay? I'm learning how to read because I don't know how to read. The ugliest girl on YouTube street don't know how to read. The hamburger don't know how to read. James Earl Jones don't know how to read. I'll catch you guys later. I'll see you guys later. I will continue this where we left off. We don't have much more to read. It's going to be a part 2 to this. I will see you guys later. So you guys can get the full reading of everything. Catch you guys later. Love you. Bye. I should be back around, I would say, when I finish. I got to do these interviews. These interviews takes about an hour to complete each one. So it's about 2 hours, 3 hours. I'll be gone. All right. But I'll be back. I'll put a notation when I'm coming back. So I'll see you lovelies later. God bless. Bye.